meeting to order, which is a continued meeting of February 23rd, 2026. First order of business, if you're able, please stand for the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Again, good morning and welcome. I am Vern Anderson, member of the Planning Commission. To my left is Paul Bergen, the Township Clerk. Grace Trinquist, with the WSB Planners. Ruben Yuso, Commission member. Amy Prime, Commission member. Phil White, a Commission member. Dick Herzog, Commission member. And we have Jason Hill, with the Town Law Center. And Kim Lindquist with WS. So the first thing I'd like to do is just give you a brief introduction here to bring you up to speed on some stuff. We'll see the public hearing. So, members of the Planning Commission, zoning administrators, legal counsel, the DNR, and members of the public. We are here today to conduct a properly noticed public hearing regarding the Windemere Township zoning ordinance, land use and zoning maps, and short-term rental ordinance amendments. As Planning Commission members, we understand that our open spaces, clean air, and natural resources are not merely amenities. They are essentially the well-being of our township, underpinning both our health and our local economy. We recognize the importance of implementing thoughtful zoning regulations to protect farmland, forests, and water quality, so that future generations will continue to benefit from vibrant landscapes and strong communities. Our goal is to carefully consider the long-term effects of development and to recommend policies that balance growth with environmental stewardship while preserving the unique rural character that defines Windemere Township. This process allows the Planning Commission to make recommendations to the Town Board, which is the final arbiter and decision maker. With that being said, some aspects of this process has been inaccurately communicated, and we look forward to providing clarification. Thank you for the trust in this commission and for allowing us to serve the township in this vital role. At this time, I want to turn it over to our planner, Kim Lindquist, for some comments.
Hi, thank you, Mr. Chair.
Could you talk
I just want to give a I want to give a brief review of a couple points that we've obviously received quite a bit of feedback. There's been a notice that went out from a property owner that was blanketed to many in the community. We've had information from emails that the Planning Commission has had that information forwarded to them, so they have that. If you send it to the Windemere Township email, that is in their packet for their information. And I wanted to just briefly run through a couple of things because there's some misconceptions about what this ordinance is and isn't. So probably the first one we've received a lot of feedback is about non-conforming land uses, non-conforming lots, non-conforming buildings. So there is such a thing as a legal non-conforming lot. So if the property you have is currently built on, you may end up in a non-conforming situation. But you do have buildable rights if you meet several criteria, and that is you can meet the setbacks, you can meet your septic requirements, and you meet the hard surface requirements. So that's required by the DNR. That's in the 2025 shoreland ordinance. That was in the 2015 ordinance, and that's directed by the state. So there is this misconception that if this ordinance passes, everyone will have non-buildable lots is not accurate. And so if you meet those three standards, which is what you need to meet in any shoreland district, then you are still considered a buildable lot. There's also been a misconception about variances and that they're discretionary. Variances are not discretionary. They are ruled by state statute. The town board or commission, as well as any community in the state, must make findings of fact related to the state statutes. This isn't a discretionary thing. You need to meet those findings. And so the commentary that this is just a discretionary that can be withheld is not an accurate appraisal of the situation. I also wanted to just mention that we have used the shoreland ordinance for the most part that was adopted in 2025. There are some minor modifications, but for the most part, it is the same ordinance. There were some minor changes that we'd enumerated in the memo that was in the packet. One, for example, that water accessory structures are just allowed in between your house and the water is 100 square foot storage. That means that decks or patios or gazebos have to be behind the front plane of your house. So that's a change from what you've seen. Regarding Planning Commission authority, there was a misconception that the Planning Commission has usurped the authority of the board and will be the final authority for conditional use permits and interim use permits. That's currently existing in your ordinance. So that's from the 2015 ordinance. That's not a change that you're experiencing today. And then finally, obviously there'll be many more comments, but the one thing I wanted to state was there was a concern about the cost associated with applications. Application fees, as well as what's called an escrow fee. So the town wants to acquire escrow fees so that they can pay consultant review, for mailing requirements, for publishing requirements out of that escrow fee. Anything that's not used as for administering the application is returned to the applicant. The reason for that is rather than taking the funds out of the general fund to pay for development or the benefit of particular properties, the applicant pays their own way. So it's a fairly common process. That means the person that applies accrues those costs, they're paying those costs rather than the township in total. So those are just a couple points that I know we've received questions about. Wanted to just respond maybe ahead of time, and then I think I'll turn it back over to the chair.
Thank you, Kim. At this time, I will have Amy Brine read the rules of decorum, which we all will adhere by in this public hearing. So, thank you.
The purpose of these rules is to set forth and establish general decorum for all attendees of the Windemere Township Planning Commission hearing. This will allow for an orderly, fair, and efficient conduct of the hearing. The rules of decorum are: please turn off all electronic devices before the hearing begins and public speaking starts. Anyone wishing to comment is required to sign in and wait to be recognized by the chair before speaking. Each speaker must provide their name and address for the official record. Speakers are allotted 3 minutes each to present their comments. All statements or questions should be addressed directly to the commission. Attendees are not permitted to ask questions or direct comments to others in the audience. Comments must be factual and refrain from including personal attacks, disrespectful or threatening actions, or focusing on personalities. The chair reserves the right to revoke the privilege to comment if, after being called to order, a speaker continues improper behavior or remarks. To keep the hearing moving efficiently, speakers should avoid repeating points already made by others. Clapping or engaging in discussions during the hearing is not allowed. Last but not least, there are bathrooms downstairs if you do need to go to them.
Thank you, Amy. With that being said, Phil White will run the clock for 3 minutes. He will advise at a 30-second notice before the end of your comment period is over. So with that being said, we'll start the public hearing. And first on the list is Aaron Wilson. Please come to the front.
I think you've answered my questions. Thank you.
Thank you, Aaron. Next would be Ron Buteau.
I'd like to speak during the short-term rental, if possible, because that's where my question is.
That would be now.
Now?
Yep.
Why didn't, I thought we were doing something else.
No, it's all part of
Okay.
all part of the process.
Okay, that's fine.
Yep.
Thank you.
Thank you, Ron.
Short-term rental, who determines the number of short-term rentals on a particular lake? Is there somebody, I know Mr. Genero used to do that way back when. That's one question. And I think I'm gonna ask them all because of the 3 minutes that we can only have. So what's the criteria per lake? Is it by number of mailboxes, full-time residents? Planning and zoning, I think, is the one who does it. And that's kind of what I'd like to know, is who determines the number of short-term rentals on an individual lake? And I guess that's the question for that. Thank you.
Thank you, Ron. Jason Benzie.
Well, I've been tracking this thing for a year and a half, and I've still yet to see a justifiable reason for all these excessive restrictions. Pine County zoning ordinance meets all state and DNR requirements. It is more in alignment with the comprehensive plan than what you are proposing. My recommendation is to adopt Pine County's zoning ordinance.
Thank you, Jason. Mike Folstead.
He wants me to take his time.
Okay, so I've got comments on the lot size changes. Again, more restrictive than Pine County. Personally, it does affect me. My estate planning, my trust planning is all now totally off the books. So it affects me personally in that regard. I would like a clear, concise reason behind this decision, besides because 2.5 is good, 5 is better. It's been discussed previously, we all know this. We made a request to have some data and studies that support the concept. Science matters. Environmental impact statements. Looking at Pine County's 2.5 to our 5, okay? I don't understand, I've been given no good reason, science behind this. Please give us data. Again, I will say, science matters to everybody. I want to point out that 11.17.1 Johnson Lake surface use was added. I know we have a significant restriction on motors on our lake. That was established when we first bought 30 years ago. We actually developed it, my husband, my son, and Sandstrom's, to protect our lakes. We enjoy our shoreline. We all enjoy our shoreline. We all want to protect it. But it goes to extremes when motorized use on open water was the original ordinance. That language has been removed, and now it is more vague, okay? I know we follow state standards. I looked at all the statutes that you cited, I looked at everything, and it does permit certain types of motorized use on environmental impact and on those lakes, like for use of ATVs, side-by-sides, as long as it isn't impacting environmentally. So my concern is that because the vague language on this particular ordinance that was put in this one, not in the previous ones, could affect the person's ability to use that. We're a small lake. I've lived on it for 30 years, and there has not been that much use in the winter. pop-ups, people go down, have a good time, get off the lake. There's never any permanent structures on that lake during the winter. So I'm concerned that the use of this vague
30
ordinance,
seconds.
okay, will affect that. Again, estate planning, well, I've lived 4 generations in this area. I appreciate our wetlands, I appreciate, and we're all stewards of our lands and waters. We live in a different time, and we need to give a strong evidence for these things. Now, I'm signed up for another, can I take my time too?
No,
I cannot.
not at this time. Mike chose not to talk, so
Yeah, but I also signed up.
that's correct. Thank you.
Take my time.
Curtis, I believe it's Tiana. Does that sound correct? Curtis, if you're here.
That is correct. It is Curtis Tiano, 36493 Pine Grove Lane. And I'm going to speak specific to the east side of Sand Lake where my property is.
Can't hardly hear
Those lots were
you.
platted in 1927, and virtually all of them are non-conforming with little chance of being legally non-conforming due to the setback requirements. In the case of the lot that I own, when I apply the requirements, it has left 0 buildable land on my lot. Practical difficulty? No, I think that's practical possibility. Assuming a variance application is made based on the practical difficulty, what will ensure the equal and not disparate treatment of all applicants occurs by this Board of Appeal? You spoke about the local economy, lake stewardship. Along our road, there are 4 generations of families. They care about the lake. Nobody is looking to cause harm to the environment, but this is a taking, and it to the point that somebody earlier raised. What is the rationale for these draconian takes of rules? I appreciate the fact that as planning commission members, you're all volunteers, you're have a sense of community, and you're trying to do the right thing, but I think you've overstepped. I truly do, so thank you.
Thank you. Chad Walsh.
Everybody hear me? Chad Walsh. We live on, we have a place on Sunset there. Sunset Drive, I think it is. I had a question for you folks, and all the folks in here. Does anybody rent their property from you or the state? I don't think we do. We don't rent it from you guys. So to continue to make ordinances over and over. Can you hear me now? Yeah. So the question was, do we rent our property from the township or the state? Did anybody rent it from them? No. To continue to make ordinances over and over and more restrictive than what the county is, does that work for anybody? No. I think we're all here for the same thing. You folks should be asking yourself that question. If all these folks showed up today and they're not paying you rent, how are you overdoing this? Why are you overstepping? Give that some thought. Maybe we'll just all enter in a class action lawsuit.
Yeah.
Jacob Steen.
Thank you, Chair, Commissioners. My name is Jacob Steen with the Little Arkin Hoffman Law Firm. We represent several landowners at the west end of Sand Lake, including DSLR, Summit Commons LLC, Sunday LLC, and others. On behalf of my clients, we strongly object to this ordinance. This draft ordinance is unlawful in substance, arbitrary in application, and defective in process. And if adopted, this will result in further conflict, further litigation, and further harm to landowners within the township. The ordinance selectively downzones a small number of long-established water-oriented commercial residential parcels at the west end of this lake. These are parcels that have consistently been zoned and guided as water-oriented commercial residential, and now they're being singled out with no parcel-specific findings and no rational basis or legitimate public purpose. The only justification appears to be animus towards my clients. The ordinance renders, as you've heard, the vast majority of properties, particularly lakefront properties within the township, is legally non-conforming to both lot size and setbacks. This is going to force property owners into undue, unnecessary, and unreasonably expensive processes for simple modifications or expansions. Zoning changes of this magnitude require a robust public process, and that has not happened here. We have consistently had inconsistently noticed meetings, inconsistently timed meetings, and repeatedly canceled meetings, even up to and including at the time of the meeting itself, such as last week. The only thing that has been consistent about this public process is that it is intended to frustrate public participation, and that is unacceptable and shameful. So we would strongly discourage you from adopting this ordinance as it exists today, and our request is simple: to proceed lawfully, transparently, and fairly. Thank you.
Thank you. Jeff and Lisa Jafkin.
Hi. I've been to a couple of meetings. We've only been in the area for 10 years, 3 full-time. We chose this area just because we love the lakes. My husband served in the U.S. Coast Guard, and we always wanted to live on lake property, and we enjoy it immensely, along with all of our neighbors. My question is, we understand the setbacks. We've come to a couple meetings over the last year and a half, and my question is, buildings that they will obviously be non-conforming with everything going through, if it does go through, but if there's a tree that falls down, a fire, it's in disrepair or something like that, it needs updating, and it's within those setbacks, will they, last year when I asked this question of someone, they said yes, you will be able to rebuild in that area, whether it's a garage, a shed, or whatever, but I guess I'm just revisiting that question.
Thank you. William and Lori.
Go first. Oh, you're not
Good morning, and good morning to everybody here. I'm really excited to see this many people out.
Excuse me, can you state your last name and
Oh,
address for the...
Lori Branham, 39669 Rush Boulevard.
Thank you.
So I think it's fantastic that we have this many people showing up. My question has to do with the lots and the non-conforming lots, such as agriculture. We bought our property in 2018. It's a 5-acre lot. There's 5 acres on each side. Well, actually, there's 5 acres on the west that was already divided a long time ago. And then it's 5 acres and 5 acres, and then you get to Military Road. How in the world would we ever get 5 acres turned into 20? Because that's what it says. That immediately makes our lot non-conforming. We hunt on our property, it's 5 acres, we're allowed to. How can we do 20? Our width is 330, how can we make that 660? Did you guys think about that at all when you implemented this? approximately 90% of the people in this township, whether they're just seasonal or full-time, cannot even meet those requirements. So when you think about that, and you consider that perception is reality, because that's all we have to go on, is the perception of this. This sounds like a power and a money grab, honestly. Am I right? Yeah. Because it'll increase, we'll all have to pay more fees, we'll all have to take up time to come and do public hearings and present ourselves before the board, because we'll be non-conforming lots. For what purpose? Tell me why my 5-acre lot, where on each side of me it's just seasonal people, why my lot suddenly has to be considered non-conforming because it's an agriculture land, that's the zone, and there's no way that I can make it 20 acres. Now that's just in my case, my husband and my case. I can't speak for all the shoreland people, but I'm sure there's shoreland people here that can speak for that.
30 seconds.
Thank you. So while I appreciate people standing up and becoming part of this commission, I fail to see any of these decisions made in the best interest of all residents. That's the perception here. It is up to you guys to prove us wrong.
Forfeit my time for Lori.
Thank you.
No. Why, we're able to do that before and you're changing the rules again?
No. That was the way it was stated.
Each speaker is allowed 3 minutes. So if you'd like to come and speak, you're next.
Go ahead.
My expectation is more people talk.
Noah, why? I believe this is your name.
Hi, Noah Bly from 92991 Evergreen Road. I've got a few lots there, and the question I have is, the typical lot is 100 feet wide existing. It's now non-conforming, it's got 2.5 acres. There's a process that a house can be put back on that lot if it meets the 3 criteria, right? However, there's not going to be a 100-foot setback, side setback, on a 100-foot wide lot, right?
Yeah, the setback isn't 100 on the side.
What's the setback for a lot?
Can't hear.
We can address that after a while, but it's 25 feet on the side here.
So 25 and 25, so that leaves 15 in the middle that a house could be built on. But it can't be built because it's not 2.5 acres. So if you think about the number of lots throughout the township, and think about what happens when someone tries to sell one of those lots, and they find out about this ordinance, and if there's a way, theoretically, that they could add a house there, but it's an unknown process, it's not compliant. Think about the incredible drop in values. There's no way, in my experience doing real estate, there's no way these setbacks and these lots are going to stand. So what you're proposing is a process, there's going to be a lot of legal action, there's going to be a lot of cost to the township, which is to us, and then at the end it'll be reversed. So it seems to me you stand at a point here where you could take a different path. Pause, reconsider these. If you go to a judge and say we've made 93% of all the lots non-compliant, it's not going to stand. It's just a matter of time. But it's going to cost everyone both to sue and then also pay the lawyer's fees on your side. So my request is, pause the process. It's not going to work in the end anyway. I mean, this ordinance is not going to stand. Pause the process, fix them, to make them reasonable, legal, ones that can withstand the review of a judge.
Thank you. Noah Cashman.
Good morning, my name is Noah Cashman. I live on Sturgeon Lake. I've been here since, I think, 2017. I'm an attorney, and I'm coming to you speaking against implementation of this ordinance based on poor public policy, its unconstitutionality, and its undue burden both on the members or the citizens of the township and the township itself. First of all, public policy, when you're zoning, the process is you take a comprehensive plan, you look at it, and that includes public input in the form of surveys and looking at the current development of the municipality. That was not done in this case, and I noticed that now there's some amendments of the comprehensive plan up on the township website, but that's putting the horse after the cart. Secondly, I was up last night and I looked at virtually every lot on Sturgeon Lake from the public access down to the south side where it hits Shorewoods at Shoreland Road. And there's only one lot that is going to be buildable. You know, our zoning administrator says, well, you can apply for a variance, but when you take the new setbacks, the side yard setbacks, which are now going to be 25 yards, they used to be 10 yards on a sewer lot, feet. If you look at the setback from the lake on a sewer lot, it used to be 75, now it's going to be 150. You're going to end up with lots that are unbuildable unless you go, if you want to do some kind of expansion, you've got to go to a variance. And so what this is, and our zoning administrator, I would say that you keep talking about the 2025 ordinance, but everybody was against that from the get-go. It's not a matter of looking back at the 2025 ordinance, it's looking either at the Pine County ordinance or the 2015 ordinance. So you end up with all this property that is unbuildable. You can't do anything to it without going to a variance. And excuse me, but variances and findings are by the very nature subjective. And so you know, there's going to be a lot of lawsuits. There's going to be a lot of time wasted. And ultimately, these ordinances will fail, and they're, quite frankly, an unconstitutional taking. Thank you.
Thank you. Dave Ellens.
Dave Ellens, 34796 Lake Town Road, Sturgeon Lake. Good morning, members of the board and residents of Windemere Township. My name is Dave Ellens. I'm a farmer from Madison, South Dakota. My wife Carly's a nurse, and we have 4 young daughters at home and our 5th child on the way. Recently, we bought land here in the township and built a cabin in one of the wetlands that is now being proposed to be classified as a lake. As a farmer, everything we do, every long day in the field and every late night, is about building a future for our family and protecting the land we work so hard to care for. We decided to build in this area because we love the simplicity, the relaxing way of life. We don't want to change that way of life, we simply want to be a part of it. We want to raise our children to appreciate the quiet, the open space, and the strong sense of community that makes this township special. I'm here today to urge you to vote against this proposed zoning ordinance. This ordinance is extreme government overreach, plain and simple. Good legislation should have a reason. It should have a clear purpose. It should answer the question, why? What problem are we solving? What harm are we preventing? From everything I've seen, this proposal has none of that. It feels like regulation for the sake of regulation. Control without cause. I previously served for the South Dakota Corn Growers Association. In that role, I spent time in Pierre and Washington, D.C. fighting bad legislation. I helped kill and defeat many harmful bills that would hurt farmers, landowners, and rural communities just like this one. If this ordinance were sitting in front of me in those chambers, it would be squarely in my crosshairs to defeat. Because that's what you do with bad policy. You stop it before it harms the people that you represent. What concerns me the most is the precedence this sets. Township officials telling landowners what they can and cannot do with the land they themselves do not own. I don't remember seeing Windemere Township's name on my mortgage. Farmers and landowners like me take the risk. We make the payments. We pay the taxes. We invest in conservation and we raise our families on this land. With those responsibilities comes the right to make lawful decisions about how our property is used. Township board members should be looking for solutions, not looking for problems. Strong communities are built by supporting responsible landowners, not by assuming the worst and creating restrictions to control them. All I've seen from this township regarding this issue is a search for problems instead of a search for solutions. If there's a specific issue, let's address that issue directly. If there's a concern, bring it forward transparently and work with landowners. But don't pass broad, restrictive ordinances without clear justification. I'm asking you today to stand for property rights, to stand for common sense, and to stand for limited, thoughtful governance. Vote no on this zoning ordinance. Thank you.
Aaron Lampert. Dave Craig.
Doug Craig.
I'm sorry, Doug.
Probably not printed very well.
The body language of Kim.
I'm used to talking to people face to face rather than with my back to them. So I'm speaking to you as much as to them.
Address those commissioners, please. Thank you.
Hang in there. So my name is Doug Craig. My wife and I have a place over on Sand Lake. I'm speaking today to share information I've collected regarding the 2025 shoreline ordinance. My goal is specific, to better understand the merit behind the substantial increase in shoreline lake sizes and setbacks. I set out to find facts, spending many hours reviewing Windemere Township and Pine County websites, along with the communications between the township and the DNR. Here are my findings and thoughts. The idea to substantially increase shoreline lot sizes and setbacks did not come from the Windemere 2020 Comprehensive Plan. Though a very well done plan, this recommendation is not in that document. Nor did this come from Pine County. Their 2024 zoning ordinance still allows for 100-foot wide lots. Nor was it mandated by the DNR, based on the feedback to Windemere's 2025 zoning ordinance. Nor was it an idea from the town board, this is the important part, based on recent water quality studies tied to shoreline erosion and sedimentation caused by development. Older Minnesota pollution control studies from 1992 and 2003 referenced in the 2020 comprehensive plan noted no degradation in water quality in Island or Sturgeon Lake. Yet, in an October 7, 2025 Planning Commission meeting, members were reminded that, and I quote, 2025 shoreline ordinance rewrites are still tied to the 2020 comprehensive plan. Again, this plan did not recommend increasing shoreline lot sizes and setbacks. In the end, I could not find any documentation, including the recent website alerts, that explained the rationale for these lot size and setback changes. Could I have missed it? Yes. There are many hours of recorded meetings and numerous pages of minutes out on the website. Still, something this important should have been front and center on the website. So it appears these changes are driven by personal preference of a small group. Note, I'm not necessarily a big fan of more development, but personal preference should not determine what happens. Data and decision-making that aligns with taxpayers' preferences should. Otherwise, it appears the town board is out to make one or two larger landowners such that they can't subdivide, and those of us with average lots are collateral damage. 3 other thoughts. First, why didn't the board just adopt Pine County's 2020 shoreline ordinance after the Sand Lake Resort litigation was settled? They met with a Pine County zoning official in February 2023 to compare ordinances, and it seemed possible to do that, albeit maybe with a customization or two. Second, why didn't they take the advice of their own planning commission that developed the 2020 comprehensive plan and focus better on enforcement of the existing ordinances? Lastly, if this comprehensive plan is meant to be a vision statement, why change it in the meeting to follow to fit the ordinance? Shouldn't it be that the ordinance that gets changed to fit the vision, or did the vision change? Food for thought. Thank you. Respectfully, Doug Craig.
Corey Lewinsky. Kay Jepson. Kay Jepson.
My husband's
Yeah,
going
I'm
up.
board education.
No problem. You wouldn't mind stating your name for the
Yeah,
record?
I will.
Appreciate that. Thank you.
I'm Chuck Young, my wife's Kay Jepson, 33795 South Sand, Sturgeon Lake. We built, Kay's family's been here since the fires of 1918. We own a lake lot, well, we owned a lake lot on the west side of the lake, about half a mile roughly from the boat landing. We took our cabin that was built in 1969, raised it up, put a basement underneath that, and did an addition to the west on that cabin lot. I worked with the Minnesota Department of Natural Resources and Pine County to get everything in order for where our lot is. We are on the old road that went around the lake. That's how close to the water we are. So I made sure everything was copacetic with Pine County and the DNR, and that's why we built where we did. I think that's important that we have people that are on all the lakes, Island Lake, Sand Lake, Sturgeon Lake, all of them, that they take care of their property, they make sure that properties are cared for and visibly acceptable to other people when they're on the water. And I also think that anything where people buy it and they want to do like rental properties or something like that, where they have stuff next to each other, that they need to make sure that they kind of go by what you guys are doing here with some sort of side setbacks or side variances and setbacks from the lake, so that they're not destroying the lakes that we have got here, that we've had here since, the turn of the century, really, the last century, not this century. But anyway, I think it's important that everybody here understand that when I worked with the DNR in 1998 to build our house, they knew that we only had 120 foot of lake shore. And the only reason we have 120 foot of lake shore is Kay's dad bought the property from his brother-in-law, and so he wanted an extra 20 feet for this one tree, so he got that. And if you go where Jerome Bennett lives, that's where Dale Sandberg's property was. Dale had 2 lots there, so he had 200 feet. That's like that all the way pretty much from the boat landing down to where Lee Anderson had his property, so that's probably 3 lots to the east of where we are. And then the lots became 50-foot lots. And so, all this stuff has been around, all this stuff has been around for a long time, and I think that the council here needs to take in consideration of what the people have done and what they're looking to do. And I don't think that unless you guys hold them to this 50-foot, 100, whatever setback you want to have, but more than anything, we just need to maintain our waterways the way that they are, because we do all take good care of our lakes.
Thank you. Jason Trimert, I believe. Trimert? Thank you.
Hello, Jason Tremert, 86790 Harmony Lane. Just got kind of a quick question. How does this benefit the current property owners versus damaging our property values for resale or anything like that? Also, the property backing like Wild Acres, Hogan's Lane Acres, our property is 100 by 200. We're planning on building like a garage or whatnot. Don't have a problem putting a septic system on it, but according to this new ordinance, the property is not buildable now, and it's worthless, is what my understanding is. I'd like to be a little more clarified on that property size and what we're able to even do with it. Because I can't grow it, can't go into the streets, can't make it 150 by 300, so I'd like to get a little more clarification on what we are supposed to do with that property. Because now the $20,000 piece of property went down to what, 1,000 and whatnot. So appreciate your guys' time.
Thank you. Dan Benzie.
Good morning. Dan Benzie, 94287 Island Lake Road. Speaking in opposition to the ordinance, and I'll focus my comments on the shoreland overlay map. Is that staticky? Okay.
Pretty good.
At your last meeting, one of you asked why there were hundreds of properties, miles of shoreline, arbitrarily rezoned from residential to the new SP district. The consultants answered that it was not their recommendation, that it was based on town policy to preserve agriculture in our shoreland zone. In my opinion, that's not good land use policy. It's not good for the township, the property owners, or the lakes. The DNR defines SP, or Special Protection District, as unsuitable to build on or of historic or natural significance. These properties meet none of those. All of Pine County only has a couple of these zones. A couple small trout streams in the southern part of the county, and this small area of the Willow River that's in our current comprehensive plan. This new map that just showed up at the 11th hour, it's shown up in the green over here, I did the yellow one here for you, is ends up being several thousand acres, miles of shoreline, and several hundred properties, none of whom have been notified that they're having significant zoning changes. And those changes are significant for them. Under this SP district, without 40 acres of land, they can do nothing on their property. Nothing at all without a variance, except they can farm it down to within 50 feet of the shoreline. That does not seem like policy that we want in Windemere. Let me just give you just a real quick example. I circled it here on this map. It would be the far upper right hand. If you look at a 200-acre block there, just east of Island Lake, the dozen or so properties there have been residential for decades. It was last farmed by Dave Waldo. He farmed that far eastern side where there's a house sitting now. And Dave used the land. He grazed his cattle down to the water. He cultivated it, spread manure every spring, used fertilizers. Where did they end up? All those excess nutrients ended up in Little Island Lake. You know they don't stay there. Under the road, they go over to Island Lake,
30 seconds.
feed our algae growth, end up with excess wheat growth in the wheat in the base. Then they head over to Sand Lake, increasing the milfoil growth. Agriculture in our shoreland is poor policy. Just to summarize, I would recommend that we take the map back to the drawing board, along with the comp plan and the ordinance, give proper notices, give broader community input like you're getting today, listen to what they say, incorporate that into the documents, bring us back a draft that better meets the needs of the township, is more equitable to the property owners, and still protects our lakes.
Thank you, Dan. Seth Nielsen.
Good morning, Seth Nielsen with Legacy Law. I represent a number of the landowners in the Tom Anderson lawsuit, as well as Sturgeon Lake Holdings 2 LLC. 3 minutes is obviously not enough time to get into the ordinance in any meaningful way. It's 150 pages. To make sense of it, you have to read the 2015 ordinance, the 2025 ordinance, the Pine County ordinance, the DNR regulations. So this is obviously a good starting place for comment, but it shouldn't be the end. Like we requested in our letter, I'll just reiterate all those requests. There should be an extended public comment period where you should receive more comments from people. There should be an opportunity for us to receive, the public to receive all of the information that's being used to inform these proposals. And I would renew my request for my clients and for any other affected landowners to have a proper hearing and to be able to contest any of the evidence that does get put forward, as well as to present any evidence of their own. Procedurally, the commission's not even following the township's own process and their own directives. Last year in April and in May, the board passed 2 purported ordinances when it said, it actually directed the planning commission to conduct studies to determine whether there were any changes that were needed to be made to the ordinances. My understanding is that no studies have been performed. I think that was brought up at a prior meeting, but you're not even following what the board directed you to do. So this proposal is completely out of place. Obviously, it's not in alignment with the comprehensive plan either, and now we're hearing that the plan is, well, we're going to fix the comprehensive plan later. but we've already been dealing with things being done out of place, just like the shoreline ordinance. That's why we're in this position today, because the shoreline ordinance doesn't line up with the 2015 ordinance, and so we're just gonna do the same thing all over again. I wouldn't be surprised if we see more purported moratoriums getting pushed forward. It's just a mess, and it shouldn't be done. Substantively, there's too many changes that are being proposed. I think most people read through this and they might pick up on a few of them that stand out to them, but there's so many changes that are significantly altering landowners' rights that this should just not be adopted. Again, the proposals on dimensional requirements, there's been no support as to why we need to increase those. The residential requirements and the agricultural requirements that are being proposed are many times greater than what the recommendation was as sort of a vision in the comprehensive plan. This whole nonconformity issue it's shocking that the county, or that the township is proposing that the majority of lots in the township be deemed non-conforming. And contrary to what we're hearing today from the commission and Ms. Windquist, with respect, it is a discretionary process. I think people don't really trust how it's going to be administered. We're not even allowed to stand up here and allocate time to other people. We're being told by the commission that we can't face the way that we want to face. I think there's just no trust here that this is going to be a good system for people. There's been massive fees at the township level. The lawyer is saying that that's just to cover costs, but that's obviously because the planning commission has chosen to hire lawyers from the Twin Cities as well as consultants, when the whole purpose of the zoning ordinance was supposed to be to keep zoning local, which obviously it's failed to do. So respectfully, I'll just reiterate that this should not be adopted and that the zoning should go back to the county.
Thank you. All right, that will end the public comment portion. I will make a motion to close public comment. Is there a second? And second. Any discussion? All in favor? Aye. Motion carries. All right, Kim and Jason, I know you folks are taking down some notes. I've got some notes here as well for our discussion here. I think we should have some more clarification on some of these processes. A lot of stuff is thrown out there. How about non-conforming lots again? And I'm not sure how you can convey that more clearly. Maybe the statute might be involved there, Jason, that you could reference how that would work so folks can understand that. And we got to remember, folks, the 2015 ordinance, I got to say, we do regret that ordinance. Not one person sitting up here was involved in that process. In fact, Tony and Al from the Board of Supervisors were involved in that process. We're put at task here to fix that, okay? And that's just the fact of the matter. And so anyways, Jason, if you wouldn't mind taking a few of these things and we can see where it goes from there.
Can you hear me? There we go. So let me just run through a few quick things. I don't know that, I think Kim did a good job of explaining the non-conforming use. There's a difference between a non-conforming lot, a non-conforming structure, and a non-conforming use. And
Speak up louder, please.
so there's a difference between non-conforming lots, non-conforming uses, non-conforming structures. And the language for the non-conforming uses comes from state statutes. So there's no kind of deviation here from, we're not being more restrictive or anything like that in the context of non-conforming lots. And, the non-conforming, the lot size, I understand the frustrations of that primary issue is going to be with subdivisions, with whatever the lot size is. I don't know if the lot size is currently, even under the 2025 ordinance, would have been considered non-conforming. But, the lot size doesn't change the setback requirements, those kind of things. So you can still, if you can still build there, there's a question about if something gets destroyed, you can build in the same footprint. You can, if just as one example, if the nonconformity is a setback, if
throwing the number out there. If the setback is 10 feet and you're a couple feet over that, this side of your house, that doesn't mean you can't expand on the other side of the house. You just can't increase the nonconformity. So you do have that option as well. So just understand, if it's created a non-conforming lot, it doesn't automatically mean your structure is not conforming. It just depends on the setbacks. But it also doesn't automatically mean that you can't do anything. So it's a complicated area, but just to kind of help with that a little bit.
Can you just clarify, why would you make everybody's lot non-conforming versus just have it apply to new lots like you did with the shoreline ordinance last year? What's the benefit to the residents of saying everybody's lot becomes non-conforming?
I don't make policy decisions. I'm not the one deciding the lot size. I'm just explaining, if it does become non-conforming, this is what the issue is.
And have a commissioner speak about it.
Okay, let me just kind of go through a couple quick questions. There was a question about having kind of lots, 5 acre lots. I think there is a process, in most counties, there is where you can combine those lots if you wanted to do that.
They're owned by other people.
I'm sorry. I thought you said you knew.
No.
The variance issue, the variance language in the ordinance comes from state statute. The burden is on the applicant to prove a practical difficulty. There are no, I understand potentially seeing it as subjective, but there's criteria that got to be met. There are findings that the board would have to prepare. And most importantly, I will say too, it is important, because a variance is a deviation from the legislation, basically. That's what the ordinance is. The ordinance is the law of the town. And a variance is a significant thing, because you're deviating from what you have established as the standard. So there's a reason why there's a higher bar to get a variance. That doesn't mean you can't get it at all. If there are situations where things are all of a sudden unbuildable, you can likely prove a practical difficulty. And I can't give you any specifics for a specific parcel or anything like that. It depends on the circumstances. But that doesn't mean they're impossible to get. There is a higher bar because you are deviating from legislation, but just to make that one.
Point of order is, so we gave our public comment, we're waiting for the zoning commission to speak. This is something else, so we want to hear the zoning commission speak to the questions that have been presented by the citizens. We're hearing all this other stuff, they're not on the zoning commission. Point of order, we want to hear what you guys have to say and how you justify it.
Yeah, well, I think we're here to try to explain some of the legal stuff.
Well, I know, but we want to hear our representatives address the citizens about why they came up with this and how to justify it.
Right, and I'm
So
gonna
point
speak-
of order.
Yeah, well, I'm going to speak a few more minutes, please.
Yeah,
because-
to be clear, you have all the time you need, okay?
I just-
To clarify.
I think we didn't.
And we all get 3 minutes.
Changing the effing rules.
Come on.
I want to try to respond to the non-conformity, because that's a question that's.
Can't hear.
continues to come up. So the non-conformities in the shoreland or in the shoreland area, which is where I think a lot of people have concerns. As the attorney mentioned, if you are a lot of record, a legal lot of record, then you have buildable status, so long as you can meet those setbacks, meet, I I'm mentioning it because several people asked. And so I want to make sure that people understand that one gentleman said he has no value to his property now because it doesn't meet the lot size. If you are a legal lot of record, you have buildable status if you can meet those 3 criteria.
Yeah.
These are the requirements for the DNR in the shoreland. That it
No, they're not.
meets the setbacks.
Not Pine County.
Yes, well, it's also Pine County. You meet the setbacks, you can put in your septic, and that you can meet the hard surface cover.
You're changing the setbacks is the issue.
Yeah.
Well, the setbacks are 150 off the OHW, which they are now for the natural environment. They're 25 on the side, and they're 100 off the rear. So,
That's a 2025 ordinance, which is defective.
Yeah.
well, I'm looking at the 2015 ordinance, and so the 150 is off of that.
It's natural environment.
It's 100.
Right, well, there's several natural environment lakes.
You double the setbacks.
We're talking about the residential development lakes.
Okay, well, there's people with both. Yes.
Yes, sir.
Seth talked about something that maybe should be clear for people that don't know. I'm Tom Anderson, I've had property for 50 years. The 2025 ordinance, everybody, that ordinance, we took legal action against it. It's talked about a lot today, Vern and everybody, that, but we disagreed with that ordinance. That's kind of the basis of a lawsuit that's pending, okay? So they're referring to it like it's law. It is law for this moment, but it was not done correctly, everybody. So just think about that for the future. I would say one more thing. If it takes this long for an attorney and somebody from WSB to explain what something means, it's not very clear. I mean, really, you guys are professionals and we're all intelligent people. They've tried for 20 minutes to tell us what it means. It isn't clear. Come on. Please straighten this out, guys. It's too much frustration for friends and family.
We understand that there's, some questions, and I would encourage all of you to go back to the 2015 and try to explain that to us, first of all. That's number one, okay? And so we are at task here today to try to correct some of that. So, excuse me.
You have questions about the 2050 ordinance?
Here's what we can do, folks. We're gonna have our discussion here orderly, and that's okay. We've given everybody a chance to talk. Everybody's had weeks to comment. Now we're gonna discuss it, sitting up front here and move forward. Okay? So, Kim, can you please finish whatever you need to do there? Thank you.
Why can't we
The only other
just
point I wanted
go
to
along
make
with
is
Pine County?
that there was a question about the Johnson Lake piece, and that is in the 2015 ordinance, but that is not going to be included in the zoning ordinance. So the person who questioned that.
So one of the other questions I'd like Jason to address here is the comprehensive plan and the alignment of that with the zoning ordinance. If you have any comment on that and the process.
Yeah, I don't know what additional commentary I can make on it. The plan is to update that comprehensive plan. Not a whole lot of changes, but just really to update the comprehensive plan to kind of match what is in this ordinance and what the board is looking at as kind of policy.
How much is this gonna cost us?
So, Dick, any other commissioners have anything else at this time to add?
For discussion.
For discussion, yep, discussion's open.
I do.
Good.
I'd like to go back to something Kim said. Microphone. Oh, sorry. Okay. I'd like to go back to something Kim said, and that
Here,
was.
you have to talk into the microphone.
It's the mic. Kim was talking about non-conforming lots and meeting setbacks. What I would like to know, and I think these people would like to know, is if they're non-conforming and they can't meet the setbacks, explain then what happens or the process or procedure.
Then they do need to apply for a variance if they can't meet the setback.
What's the setback?
So if you, the setbacks, you know, there's the front yard, the sides, and the mixed use, right?
And
I didn't hear that.
On variances, on
Speak into the microphone.
sorry. On the current comp plan, right in the very beginning, under major recommendations, this was in the 2020 comp plan, it talks about zoning variances. And it says, grant fewer variances to the zoning regulations. That was a recommendation in 2020. So now what I see happening is this new ordinance, we're gonna have a lot of variances coming through, which doesn't even line up with the comp plan.
I'd like to make a comment.
If you get denied, you gotta wait a year.
I was on the comprehensive plan when we made it. That was done with the residents, and people were, requested their time at these meetings, 14 months. And the comprehensive plan was a guideline, not the law, for the future. And as time went by, the board was supposed to adopt these 5 at a time, once a month. Never happened. So what we're trying to do is use the comprehensive plan as a guideline for any changes that were done. So to bring the comprehensive plan up as the rules or the law is false. But we have tried for the last over a year to spend these open meetings that we've had. Every time we have a meeting, by law, we have to have an open meeting. And I am really happy this is an open meeting. We've got a lot of people here with comments. But we also have a lot of people that aren't here that agree with what we're trying to do here, and that's protect our lakes. Okay, you said that, but I'm just telling you, it's the law. And we are also guided, and everybody seems to want to bring up Pine County and the DNR, and the rules aren't there. But everything that we have presented that goes with the DNR and Pine County has been approved. That's in this shoreline and the shoreline ordinance. And every time we draw something out, write it out, we send it off to them, and they approve or disapprove. So that's where we're at. We are not the final arbitrator of this this shoreline ordinance or anything. The board is. We have worked on it to present it to the board, and the board has the final say.
You know, did you think the DNR doesn't have anything to say about the waterways? When we built in 1998, we case from here. Her family goes back here forever. We had one of her relatives do the construction of our house and another guy from the River. The DNR was out there every 2 to 4 days, seeing what was being done, where it was being done, and how it was being done. So don't tell me that the DNR doesn't have anything to say about the waterways in this township, or this county, or this state. They have more power than any police force in this state as far as what goes on.
I don't think I said that, but the DNR only has waterways. And then it goes into Pine County.
No, tell Kurt Russell that about going out and stopping people deer hunting illegally. Tell them that that's only on the law.
All right, thank you.
That's not
Thank
true.
you.
But anyway, we are not the final arbitrator of this. We have worked on it. We're gonna decide whether we can go forward with this or not, but the final arbitrator is the board.
Thank you.
Phil, the
So-
2025 plan recommended setting the setbacks the same as they were at the time, which was 75 from the lake on a sewer lot, 100, on a sewer lot on a recreational lake, and 150 on a natural environment lake, as recommended, keeping the same setbacks. You were on the planning commission. Tony Bakhtiari was on the comp plan advisory committee. So was Vern. So all the stuff about when I hear you guys say, well, we didn't know about it, we weren't involved. You guys were all involved. And you kept it the same. And now people want to know, why are you changing this? Tell us.
So let's
Give
address
us a
that.
reason.
Excuse me, Noel. You keep talking about these differences in setbacks. So what you said is both accurate there, right? 150 feet on natural environment and 75 on a sewered lot, which by the way is only Sand Lake. Okay, that's the only lake that has sewer, section 5 and 6. Sewered lot is 75 feet.
If you have sewer, like you've got a holding tank.
No,
yeah.
excuse me, that's not correct. Sewer lot is
That's what I was told.
municipal sewer. A private septic system is different. So the private systems are 100-foot setback on your rec lakes.
So now you're gonna make it 150.
It's across the board. It's 75 on a sewered lot still.
No, it's not.
My point is,
No, it's not.
you guys said that you didn't have anything to do with it earlier on. You were saying you didn't have anything to do with it. You guys were all involved. And it seems to me
I can stand to be corrected, so
we've got a
thank you. I have no
minority
problem
who
with
is,
that.
who is
I
trying
have
to
no problem.
implement something
Noah.
that maybe they lost earlier.
So, I make a motion for a 15-minute recess. Do I have a second? Second. All in favor? Aye. We'll recess and reconvene at 10:30. All right, we'll call the meeting back to order. Folks, I'm going to read something here that I have read before at multiple public meetings. You may find it interesting. This is from Pine County.
We can't hear you back here.
It appears that gross mismanagement of this watershed, both legal and illegal, has occurred over many years. Much unwise development has compounded the problem. County state aid, Highway 46, and other roads in the area also have some bearing on the situation. As use of this land has increased, it seems like things have been done with mainly consideration of conditions at the time. That was written back in November 6th of 1973. Here we are in 2026. Currently, the DNR shoreland management was adopted in 1989. It's not been updated in 37 years. The DNR allows municipalities to have stronger regulations to protect the resource. Windemere Township is one of the most unique townships in Pine County. I'm not sure many people realize that we have 21 main lakes in this township. Not many can say that. For that, we are unique and we are special. We should appreciate that. With that being said, there has been plenty of study done to get to this point. Some of the study shows from the DNR that 25% of our septic systems, private systems, are failing in the shoreline area. It's 25%. 39% of them have imminent health threats, which can contaminate groundwater. Tom Anderson would know that. We're all for responsible division of land, property rights. We need to look at this in a respectful manner to preserve what we are enjoying right now for the next generation. Because we're going to pass it on at some point. This township goes back to my great-great-great-grandfather, who his name is probably on some of your deeds.
You're not the only one, Vern, mine too.
Yep.
Since 1896, my family's been here.
Thank you. So this township is a special place for many. That's why we're here. We're trying to find common ground on this, and I think we can clarify a few things here.
Common ground with who?
Excuse me?
Common ground with who?
Public comment is over.
Well,
If you choose at some point, you can call any one of us sitting up here, and we will talk about your individual property at length, okay? You, sir, have a 100 by 200 foot lot. Your lot is buildable by state statute. No questions about that. You have to meet your setbacks, you have to meet the septic standards, okay? Your lot was created 50-some years ago by her dad, right there. Okay?
so what?
So moving forward, I don't have anything to say right now, but I'll open it up to anybody else sitting up here for any more comment and what your thoughts are. So, Bree, would you like to say something?
Sure. Let's go. Can you hear me? No.
Can't hear.
Can you hear me now? Okay, so let's go back to where we left off. And on this new ordinance, it would be on page 63, this draft ordinance. And it's talking about the setbacks on natural environment lakes and recreational development lakes. And the natural environment on both unsewered and sewered is 150. On recreational development, it's 150 unsewered and 150 for sewer. Now, first off, the DNR requires 100 feet on the unsewered and only 75 feet on the sewered. So, in my mind, we're quite restrictive. But, more so, the point that I would make with this is I have heard it said from the different committee members and the town board that on sewer properties, if we get sewers put in, we're gonna be less restrictive, which in my mind makes sense. So this is just an example, and again, in my mind, where it's not less restrictive on sewer. We're 150 unsewered setback and still 150 on sewer. So in my mind, you know, that should absolutely be changed. So that point,
Do you want to discuss that
sure,
point
let's
first?
discuss that one.
My thought is the same as yours. I think when we have a sewer, that's the goal, the hope of what we would like around our lakes is to get a sewer system. I know that the board has discussed this. It has been a nonstop conversation of getting sewers. And I don't agree with the 150. I think we should look at the 75 because
that follows along with, I believe, Pine County as well as DNR. So I do agree, we should consider changing that to 75 for sewer lots. And then also on the, following with, if we stay with kind of the DNR regulations, perhaps we should stay with the 100-foot on the sewer, unsewered, I'm sorry, and that follows the DNR. I guess I'd be curious what other people think.
Now, it's recreational development.
Yes, we're talking recreational. Natural environment's 150, and that's required by the DNR, is my understanding.
Did we not address this?
Microphone, please.
Did we?
Did we not address this 2 or 3 weeks ago? And it was supposed to be put in?
We did, but we're also listening to the public and discussing it now.
Oh, okay, so we discussed it and put out to the community? Is that what we're saying?
Pardon me? Say that.
It was addressed by the planning commission, but it wasn't adopted and put out to the board or to the residents?
Well, it has been out there,
That's-
but this is what I'm hearing today. I'm hearing discussion today, and so being mindful of our position as public stewards, I think we should consider what's being discussed. From
I agree, but isn't that what we already agreed to?
We're hearing to discuss it and make changes according to what we're hearing from the public.
Okay, well, I'll say the same thing I did when we discussed this in our meeting. I'm for it.
Kim, can you tell us what the 2015 said, please? I know you said you had it up as far as setbacks go. Now, keeping in mind, this is in the shoreland.
Yes.
People that don't have shoreland properties, you will fall under different guidelines, okay? I know a lot of this has been focused on shoreland.
So for the shoreland, natural environment, unsewered and sewered is 150, and the recreation, unsewered 100, sewered 75, and that's from the OHW, so the water, high water mark.
What about the streams?
The tributary is 100, unsewered, and sewered is 50.
All right, I'm going to make a motion that we would change. I'm sorry, Dick, I jumped you, but go ahead. You have something to say?
No.
Okay. All motion to change the rec development back to the 2015 at 100 on unsewered, on sewered structures, 75. Tributary streams at 150, and I'm going to say 75 on sewer, so that would be a minor change there.
I will second that.
Any more discussion? Hearing none, I'll take a vote. All in favor?
Aye.
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 Motion carries. Now, folks, to keep in mind, the 2015 ordinance, which everybody's been operating under, there's been a 2.5 acre minor subdivision minimum since 2015. So there's not a whole lot difference if you thought you had a non-conforming lot now, you had one back then.
It was 20,000 square feet though, right, Bert? 40,000 square feet?
So Amy, did you have anything else to bring up?
Not 2.5 acres.
So we're staying the same on natural environment, is that correct?
Yes, yep, that would be the same.
So that would be the 150?
Yeah.
All right.
So,
All right.
How about some discussion about side setbacks, which will increase?
so my next conversation was side setbacks. Thank you. And Kim, what are they currently proposed at in the shoreland now? Remember,
25 feet.
25 feet. What is a non-shoreland ag property at 20 acres proposed at?
65 feet side yard.
What page you on, I'm sorry?
Oh. I'm on page 31. It's the table at 3.43.6.
Good.
Wait, that's not nice. Well, that's minus. So go to section 3.6.
3.6, okay. Thank you.
Microphones, please.
It's 31. Page 31.
So this has been out to the public for a couple months now, and specifically talking about setbacks, I think a lot of this has been on shoreline, but there's multiple other districts that are within the town here with sewer and unsewered lots. And so I'd encourage folks to review that on page 31. So I think the one that I'd like to talk about a little bit more is in the residential. And looking at side yard setbacks here. Right now, it appears to be 20 feet. Is that why I'm reading this, Kim?
So for the R2 residential in the unsewered, it's 15-foot side yard, and sewered is 10
Okay.
in the non-shoreline.
In the non-shoreline. So let's go to the shoreline district, and what would that be?
25, it's the bottom last sentence there on page 31.
Okay.
The table on 63 has setbacks and some other things for the shoreline.
So I guess I'd like to bring it up for discussion as far as 25 feet as a side yard setback.
It's currently 10 feet in the shoreland.
Yes, that's what I thought.
It also distinguishes between accessory and non-accessory, or accessory and primary structures.
Yeah. So
There's also, just to make a comment here, you still have to have setbacks from your neighbors, sewer, and well. That can't be changed.
This is part of the problem we got here.
That is part of the problem.
Yeah.
We're trying to cut this off before we can't control it any longer. We want sewer. I want sewer, okay?
If we had a municipal sewer system, we wouldn't be having a lot of these conversations right now. That would help.
But we have that on Sand Lake.
So in the shoreland, in the 2015 ordinance, unsewered has 15-foot setbacks, side yard setbacks, and for sewered, it's 10. Accessory structures for both unsewered and sewered is 10.
Leave it the same. I make a motion to mirror what Kim just said there, the 2015 for sewer and unsewered, in the shoreland only.
I'll second that motion.
Any more discussion? All in favor?
Aye.
Aye. Motion carries.
Can we go over the agricultural zone?
Yes, in the shoreland.
I know, but I know.
Whatever I got. Well, let's talk about the 5 acres. I think that's excessive. At the last meeting, that we voted on the 2025 shoreline ordinance, I was in agreement with the 3 acre instead of 5 acres. I still feel that 5 acres is excessive. I would be more comfortable with the 3 acres. what our comp plan says, so from the 2020 comp plan, not with any changes that are coming up, but the current comp plan, I believe that suggested 2 acres in there, which was an increase. They were saying, let's increase from 1 acre to 2 acres. Yeah, minimum lot size is a rural residential area, unsewered. So the comp plan, there were a lot of people that participated with this comp plan. And I don't see going past 2 acres in size.
So what you're suggesting is that agriculture, you think they should go to 2 acres?
Oh, I didn't realize we're talking ag, I'm sorry.
Well, we're talking outside, but there's a lot of ag land in the 1,000-foot setback.
I'm talking in R2, residential, unsewered.
So we got to remember, this is for new development only. We have, now I know it sets a standard for other lots as well, but if you're legal non-conforming, you still have the ability to build. Okay, that's just the way it works. I'm struggling with this one here because knowing that we have 300 acres on Sturgeon Lake that is undeveloped, and that's an area that is, it's now considered a sensitive area. There's like 260 some lots on Sturgeon Lake, okay? And the majority are already developed. The DNR has about 5 a mile of shoreline. And then we have the Overland Farm, Nystrom Farm, and us locals call it the Vikowski Farm. Okay? And I'm saying we ought to look at responsible development until sewer comes in, especially in these areas that have been farmed for 100 years and with no shoreline problems. None. Everybody else that's got a lot on that lake, some of us included sitting up here, we've had shoreline problems because man's come in and screwed it up. This is the way it is. There's maps sitting over there going back to 1939 and 1965, aerial pictures of Sturgeon Lake. That's what was available. You might find it interesting to take a look. My position is, until we get sewer in, 5 acres is reasonable. Many other municipalities are doing the same thing. They're actually increasing to 10-acre minimum. And if we don't start to protect this now, 1973, unwise development. It's been going on in Windemere for decades. Nothing's been done about it. That's my position.
You're talking new.
This is only new developments in the shoreline, 5 acres. That's it. You folks are buildable, you're good to go. You don't have a problem at all.
Except that it states where we live, that we're not conforming because we're now not 20 acres.
You are correct, but you're also a legally created lot. By statute,
Okay.
you are buildable, you can expand if you meet your setbacks, your impervious surface, and your septic regulation. It's that simple. The whole township is non-conforming, not the whole, but many lots are non-conforming in the town.
So we still need to get a variance?
No variance for a legal non-conforming lot.
Thank you.
You're welcome. Bill, would you like to add anything, Dick, about this conversation?
Hey, Vern, I just have a quick question. If your lot is not conforming, comes time to sell that lot, does it have to be advertised as such non-conforming lot?
No.
The material fact.
Well, personally, I have 3 non-conforming lots. and my house is on one. And this goes back to 2004. I have a non-conforming lot, and I removed my cabin, and my restrictions were, this is in '04, I could only build on the footprint, which was fine. I built on the footprint, it's there, and they're all, all of these smaller lots, the non-conformity is that things have changed. And if we all think that nothing will ever change, then there is changes that have happened over time. And they affected me, but I also, and I like to make this point, because of my non-conforming lot, my neighbors put their septic system holding tank 10 feet off my property. You can't do that anymore. But it did affect me personally. My other neighbor put their well on the property. I have to be 50 feet away from that. So as we're looking at these properties and trying to plan for the future, we got building setbacks into these so we don't run into these problems. I just think it's forward-looking.
Thank you, Phil.
Vern, I ask a question here? So I get the focus on the size of the subdividing, right? As it might relate to lake quality and that. I'm a geologist, geophysicist by training. My point or my question in all this though is the quality of the lake isn't going to be as affected by the size of the lots as it is by the rules and under which the building is done to prevent erosion into the lake and so on. And I'll give you a case in point with that. If you actually look at studies that have been done, this is controversial, I'll bring it up just for comparative. Wake boats, far more destructive to the bottom of a lake and to toothfish and so on than properly done development, even if the places are kind of close. There are simple ways to control erosion, but the trick in all this, all of it, wake boats and anything else you might require some amount of enforcement. And that was even stated in the 2020 Comprehensive Plan in Section 2-11. They heavily recommended more enforcement. You guys made references to the septic system. So my point just is, as you evaluate and make decisions like this, how big should the acreage be or whatever, please don't lose sight of the fact that size isn't the only element in whether the lakes will be affected or not. There's easy engineering ways that aren't that expensive to control that erosion and so forth into the lake. It's also the enforcement element of things that already exist.
Okay, Vern? 1 second, Phil, go ahead.
Okay, you mentioned wake boats. I'm just saying, this is the next thing on our agenda. As a comprehensive plan, we've already done research on it. We have worked on it with other states. We've worked on it with Caribou Lake, which has an ordinance for it, and we're aware of it, believe me.
Okay, I didn't bring it up for discussion, I'm just using it as an example of what that's like about this.
Vern, would you consider looking at the ridgeline setbacks in the R2 zone?
I'm sorry, you said that what?
The ridgeline setbacks in R2.
The bluff?
Yes.
It's the same.
Should be 30 feet across the board.
That hasn't changed?
Somebody had a question, and I'm okay with constructive conversation and questioning. If it gets out of hand, we'll move on. Go ahead.
I did raise my hand, Vern. I'd like to ask you a question. This kind of affects, the question I have is more about like the boathouses and the gazebos and the setbacks and everything and such. So personally, we have private property, residential that is, and commercial. How does that affect us commercially?
That's a good question for our planner, to be honest about it. And maybe if you want to consider this, to just bring her up after the fact or catch her, when the meeting's done. Is that okay? So be more than happy to talk about, like I said earlier, we'll talk to anybody individually about your properties and your situation. That's no problem. Okay? Thank you.
So I'd like to go back to the acreage for new development. I just want to stay focused on one topic at a time.
Sure.
So I want to make a motion that we look at 3 acres within the shoreland for new development. Is there a second?
Is there a second on that motion? Is there a second on that motion? Motion dies because of lack of second. Is there any more discussion on the shoreland 5 acres at this point? Dick, could you please grab that microphone and so folks can hear you?
You have to turn it on.
I've watched a lot of growth in different areas along with everybody else. To me, I voted for the 5 acres as a tool to slow the growth down so the infrastructure can catch up. We need sewer. And that's my primary reason for voting for the 5 acres. After the sewer goes in, if the next generation wants 100-foot lots, do it. But somehow we've got to catch up with the sewer.
Yes, sir.
I think that's a really good point. And I would say that properly done. Okay? So a while ago, we talked about the 5 acres and the 300-foot now rule for that affects 4 people in the room, and we are one of them. And the fact is, the governance of a septic system and the governance of building, like you said, is a big deal. The reason you would allow 2.5 versus 5 is so those 2.5 acres of lots could pay taxes, so you could afford a sewer system later on. That's why it was done that way. If you want to change it to 5, think it through completely. We're going through things one by one. But that's why you have more lots in an area that should, you have to develop. Anybody ever been to Houston? Okay. They don't have a central sewer system in Houston. It's the most expensive place to live in the world for sewer. Okay, because they went too fast with oil. So, great point, but you need tax dollars to put that development. Okay? Nothing wrong with a 2.5 acre lot off the shore that's got a conforming sewer system that is enforced. Okay? They got great systems. I want sewer on this lake. At this point in time, we love this place. We did a lot of investment. We probably have more shoreline than anybody. I will pay my fair share for sewer on this lake. Get busy with that. This will all get solved. So, you're doing a good job. Just keep it up. But be fair to everybody.
Can I just make a comment on that sewer too?
Sure.
Okay. So a point was made, someone I talked with, that.
Could you talk a little bit louder?
Yeah. When you have 5 acres between properties, the cost of connecting those 5 acres with a sewer system is going to be more expensive. So you have companies come in to bring in a sewer system. You've got to look at the distance between the properties and the cost to connect them. It'll be more affordable if you have 2.5 acres versus 5. You have more properties to connect, making the cost less across the board. So I think that's something that should be considered. And I'm all for sewers. I mean, we just had ours replaced, thank you, Penn County. But it's very important that you look at that total long-term picture of distances, costs. Sewer is great. Got to think of that.
Thank you.
Yeah, and I appreciate that because I do think if we could get a sewer in here, there is a lot of things that can change. And I know that's the focus and the goal of the Planning Commission, and I believe the board as well, to try to do that. And I agree with you, things would change if we could get that sewer, and it's a lot of work, but that's a goal.
Can I make a comment here? On the sewer system, last year at our annual meeting, we had bowling contractor that was going to, we had been talking to them about septic. We also had the legislator for the federal that was going to apply for an $8 million permit, that they could get us $8 million to work towards septic. We cannot afford to do sewer by ourselves as a township. If we can do 10%, that would be accomplishment. But we also, it was voted down, and when we apply for these grants for septic, we don't get them that day. It can be 2 or 3 years before they ever get to our grant, because we're still put at the back of the list. And as they work their way through, we can get this. So if we apply for these grants, maybe in 3 years, we might get that. We were just looking at basically, at the time, getting to Hogan's Acres. Very dense population, and they already have some issues there with compacted sewer systems. A lot of those are half-acre and 1-acre lots. And when we looked at it as a board, that's where we had to go. And it's sand ground. And this really and truly, in that area, it's getting into the aquifer. And you can ask people that are putting filter systems in Hogan's Acres because of groundwater contamination. And groundwater aquifer in Windemere Township is township-wide. It's not just under there. The aquifer is very large.
All right, thanks.
Vern?
Yes.
So when you're talking about the sewered and unsewered, in R2, in this proposal, it's still asking for 2.5 acres, residential sewered. And I go back to this whole thing with you guys saying, or different people saying, that if it's sewered, it's being, will be less restricted. I don't understand why somebody would need 2.5 acres to build a house when it's sewered.
Okay.
One of the things, Corinne, that we talked about was these 5-acre parcels that are in the shoreline. Our hope is, as they become sewered, they can be subdivided, and you can get more lots. But if you go from a 2-acre lot, how do you subdivide them into smaller lots? Or if you have 5 acres, you can do 1.5-acre lots, or you could do things like that. So we're hoping that that would be something that we're trying to control now.
The other thing with your new platting subdivision ordinance, that's part of this, or that section within the ordinance, I mean, it's very restrictive on what you have to do to become compliant and get your plat through. So that is something else. When you're talking about these new developments, it's not like somebody just walks in and says, I want a new development, and you're granted. You still have to work through, getting certain number of soil tests on every lot, wetland delineations. You have to be aware of anything that obviously are swamps on the property, things that would prohibit building. So that also does help keep everything in line when you're platting it.
Well, that would be a PUD.
Well, just a plain old lot plat,
multi-dimensional development.
No, but just individual lots, if somebody's gonna subdivide their property, they still have to meet all of those requirements too.
Yeah, if they're gonna subdivide 3 or more lots,
Then it's a plot.
then it's a major subdivision.
Yes.
A subdivided plat.
Yep.
So that is the difference there. In this R2 district, we have a lot of R2 within the township here that would be unsewered. Okay, I mean, it's on this particular map here, which is over there. And so what I want to, just for clarification here, is bounce us back to Kim, if you can just briefly explain the underlying district of the zoning map and then the shoreline overlay, and how they complement each other, and what takes precedent. Can you give us a 2-minute explanation of that, Kim?
Yeah, thank you, Mr. Chair. So the entire community has a zoning ordinance, so every parcel is zoned, and then the shoreland overlay sits on top of the zoning. And I think most people do understand that in the shoreland, they should be primarily looking at the shoreland ordinance, because those generally have more restrictions based on the regulations, because it's on the shoreland. But you need to complement both ordinances.
So yeah, just to be clear, you've got to kind of work on both if you're in that particular district. If you're outside of the 1,000-foot mark of a classified lake or 300 feet of a classified river, it doesn't apply. And it's just the zoning district that is on there. So there's multiple districts within the township. There's 1, 2, 3, 4, 5, 6, 7, 8, 9 districts plus a shoreland overlay. And so you got to really understand where you're at, based on the current map and how that would affect your particular property. Okay, so that's, you just can't throw it all into one basket and say, yep, everybody's the same, because it just doesn't work that way. So, anything else at this point? Oh, I'm sorry. Go ahead.
Vern, I have a question on the 4 new wetlands that are now considered high main basins.
You're on the list. You're next.
I'll just sit down and wait for you then.
So, but I want to finish up here, but it is my list, yeah. Go ahead.
So, I don't know if this is the time to talk about the rear yard structure setback also, which is now 100 feet, I believe.
Which district are we in? Yeah, are we in Greenville?
It's under additional structure setbacks, page 63.
Yeah, it's in the shoreline.
So, I had a question come through from a landowner who has an existing structure. I called Grace and I went through the scenario. He wants a garage on it. And we measured the lot off, and my first question is, what's rear yard when you have a lake or a road? What is your rear yard? And I believe the understanding I received from Grace is that it is from the ordinary high water mark of the lake, correct, Grace? Your lake.
That's correct.
That's the 150 and the 100 we've been talking about. That's the 150, the 100, and the 73. That's from the ordinary high, not the rear. I can't hear you, I'm sorry. Oh.
That's always been a question. I was doing zoning for years. People would want to permit, I'd say, what's your backyard, what's your front yard? People would say, oh, the lake, right? Some people would say, oh, it's the road. It's got to be defined. And it is defined.
Yeah, that's yes. What did you say? The shoreland requires that 100, 75, and 150 we just talked about. That's from the lake side. That's not the rear. It's just from the ordinary high is how it's defined.
So is this saying that 100 feet in from the road? Is that what this is saying? On this graph or chart?
So you're on section 2, correct?
Paragraph 2, yes,
Yep.
under
Page 63.
10.11. Yes, yeah.
It's section 10.11.2, Kim, placement of structures on
Yeah.
lots. The property
So
in the
it's-
shoreline
it-
district.
Right, yep, so the rear yard is the portion of the yard between the principal structure and the rear building line and the rear lot line. So it would not be the lakeside.
It would be opposite.
So if this gentleman has approximately 140-foot lot from the road to the lake, or actually, yeah, his lot size, his house is by the lake, would he need a variance to get a garage up by the road or closer to his house, which is near the lake, if it's about 140-foot depth from the road to the lake?
That would be my assumption. Yes, I mean, it's 100 feet right now in the ordinance, so the commission may want to look at modifying that also.
I agree. I think 100 feet is too much. It limits a lot of people. I've heard a lot of comment about it indirectly in different ways.
Question. What is the setback from the road to the front of the structure? Because when you live on a lake, the lake is, if you look at it like everybody else's houses, your front yard faces the road and there's a setback on the front, and the lake is your rear. People tend to look at that as the front yard and the road is their back, but there's no rear setback. You've got your front yard, you've got front setback from the road, you've got your sides, and you got the lake. So determining a rear setback doesn't make any sense.
That's where we're getting clarification. Thank you.
Talking about that right now.
So the 2015 ordinance has a rear yard setback for the principal structure 20 and accessory structure 10.
To add one thing to that, there's also.
Can't hear you.
There's also road right-of-way there, so it should be 33 feet from the center line of the road, but in our township, that don't mean nothing. We need a survey.
So what was the 2015, Kim, on the rear yard? Is that 20 feet?
20 and 10 for the accessory.
Now, this is specifically the shoreline
Correct.
in the overlay district, so.
Correct.
I move to reduce that down to 20 feet.
Oh, sorry.
Any more discussion?
For accessory.
Here we go.
Say that again. Your motion is?
To put the rear yard structure setback to 20 feet. And I would say, all right, we'll go for any discussion right now. So what I want to clarify on this, Kim, is now these structures, accessory structures on the rear of the building. Is there language about that in the 2015 or?
That was the 10-foot.
Because in reality, if you got to meet your setback of the road, 33 feet or 53 feet.
This is your property, you can't be in the road.
No, but I'm just saying the road right away, you know, you got to be off of that as well. And so the 10 foot was almost irrelevant in a way to be any closer. Well, if you got to be from the center of your road going in 53 feet. You got 33 feet plus. In some locations, there's a 20-foot utility easement. So that's where you get the 53 feet. On a county road, it's 73 feet. And so there's a greater distance there about being within that right of way. So what I'm trying to get as, to simplify it, I'm going to say just keep it at 20 feet all structures. Go down from 100 to 20 feet, and that would be my motion on both accessory and principal structures. We had a second, we had discussion, all in favor?
Aye.
Aye. Aye. Aye, motion carries. Thank you.
Can I ask a point of order?
Go ahead.
I don't know about order, but.
I don't either.
Is the public hearing over and this is now just a normal planning session?
Well, so we closed the public comment a while back, but I felt if we're having a civil discussion like we are, we can continue on. I've got no problem, I'll sit here all day.
So we're in public hearing still.
So, public comment is closed.
Public comment
Is closed. But I will take questions and go from them, so go ahead.
Okay, I have a question and a suggestion. You're kind of going through the basic points that everybody brought up one by one, right? And in totality, then this will be presented to the board. It's going to be a bit confusing what was done and what wasn't. Okay. Is there a logical step to say right at this moment, you go back to the 2015 size regulations and do a regroup? This seems a little bit broad of what is now being done point by point, lot by lot, and just personally, we're not discussing the big development potentials. So I suggest going back to the 2015, end this meeting, and then start over with your proposal to the board that we can all read again. It's a little dysfunctional to me, but I appreciate calming it down, keeping respect in order. I'm kind of confused with that. Thank you.
So I'll answer that for you. No, we're not going back to the 2015. We're in a moratorium, okay? Which puts us up against a timeline to get this completed before that interim ordinance expires in April. So right now, there's no development, there's no zoning permits for anybody in the town. We're at task to get that taken care of, recommend to the board so they can get that approved, and then once it's published in the paper, it becomes in the ordinance, okay? So that's where we're at right now. As far as these changes go, this is how it works. We also we're gonna make an addendum. It's gonna reference the changes we talked about today and anything else that may come up, okay? So the draft will be the draft on, I think it's 212. That will stay as it is. Then there's going to be an addendum with all the changes, whatever they are, and it's going to reference them back to the ordinance. So when we get to that point, we're going to recommend approving the draft with the amendments to the board. And at that point, if they decide to approve it as it is or make changes, then we will move forward there. But the caveat in all this is the DNR has to weigh in on what we just talked about. So they will have say-so on this as well. They have a 30-day comment period. Whether they'll take that or not, it's unlikely. We have a good relationship with the DNR, and they are fully aware of what's going on in Windemere Township. So that is kind of the process, the logistics, and the timing. And so yes, I'd like to move this forward at some point here and get this going because the clock is ticking for the interim ordinance. So one last comment, Tom, and then I'm going to go to some other hands.
Thank you for the clarity. Then when it's the proper time, I'd like to make a comment on the 300 to 150 foot change. That's my remaining point.
All right, thank you. So I'll start over here. Ready?
Friday, Wickstrom. We've been on our property for 130 years by family, and I'm wondering which map do we go by, the right one or the left one? The one says special protection district, and we're in agricultural right now, so how would that affect us? The other map is showing that it's, the one on the left is showing different zones. So as it affects us and then our neighbors to the south of us, they also have acres and we're all our country here.
Yep.
So we get to speak on
I'd like to do with your particular case is we'll refer this to zoning when we're done here today, and then have that conversation. Noah, go ahead.
I have a question for discussion. Under the new ordinance with stairways and landings, you require a licensed engineer to, I guess, provide a plan for the stairways and landings. That's a big change from the previous ordinance in 2015, and I think you should discuss it, because what happens is you have somebody who can put up stairways and landings, especially like on Lake I'm on, you're up on a bluff, and you have to pay for your retreat lumber, you put in footings, and so forth. But now if you have a licensed engineer doing a report, that adds a very significant cost to somebody putting up stairways and landings. And you're going to get a lot of people doing it illegally, so it's going to also be an enforcement issue. So I would ask you guys to discuss and perhaps amend that and just require a permit for stairways and landings. The township can come out and look at it, but to have a licensed engineer do a report on any stairways and landings seems very cost excessive. Thank you.
Thank you. We'll take a few more questions here. This lady right here.
In the past, people have spoke and you guys just don't even answer questions. I came today assuming you were going to do the same thing. I didn't know that we were actually going to discuss things today, because in the past that hasn't happened. And there's a lot of people who did not know that this meeting was going to be that. So I am asking that we put this meeting on hold and have a meeting to continue this, because a lot of people are leaving and there's a lot of questions. If I would have known that you would have addressed my question, I would have got up and asked questions. But I just went by the past. You never listened to anybody. So I'm asking if we could please do that, because it's not fair that it was not posted that we were going to discuss these things, and people have to leave, and they have questions. We could be here all day, and we didn't know that this was happening. At least I didn't know this was happening. I don't know about others. So I'm asking that we put this on hold and have another meeting that says this will continue and we'll have discussion about this.
I'll clarify that. So this notice was, or this meeting goes back to February 23rd. Okay? This is a continued meeting from them. Previous location wasn't adequate, so we continued it till today. Prior to that, it was published in our paper of record, Star Gazette. It was also posted at our town hall building where the bulletin board is, which is our statutory requirements. The town has gone above and beyond to try to put information on the website. This information has been out there for just shy of 2 months. And so this is the time for this. We are a little bit out of character since the comment period's over, but I feel as long as we're civil like we are, we can have a conversation. So if you have a question, I think we've been trying to address and answer them as things go along. I'm going to go to you and then to this gentleman over here in that one, so go ahead.
So in the shoreland area.
Speak up if you don't mind.
Yeah, in the shoreland area, a non-conforming lot, you made a point earlier that a non-conforming lot was buildable if it met the setback requirements.
Setback, septic, and impervious surface.
Right. So can you speak to the impervious surface changes that are part of the new ordinance?
So the change, actually, if you're in shoreland, that's a DNR, they regulate that. Kim, I think it's 25%, is that correct?
You have to be under 25%.
Under 25%.
So that's no change from the current?
That's correct.
Okay, thank you.
Yep.
So, yeah.
This gentleman right there, in the Under guy.
My name is Bill Stork, and I'm family. I moved here in 2020, and I worked for interviewers. But we live on the golf course in the called the Viking Edition. All of the lots in Viking Edition are 2 acres. So you're saying that that's an unbuildable lot?
No, that is absolutely not. These are legal, non-conforming lots and lots of record. They were created lawfully and file with Pine County with a current PID number, there are lots of record. You have no issue. Thank you. Yes, sir.
Can I follow up on that?
Go ahead.
The non-conforming lot, let's say 100 by 250 typical lot.
Yep.
It exists right now. After, with the 2025 zoning, you're saying there's no issue with building it.
That's correct.
Is
As
there-
long as you meet the standards of the septic, the impervious surface, and the setbacks.
So if it's not possible to, that, the house is sitting there now 80 feet from the road and 10 feet from the side lot, it's non-conforming, right?
Correct.
So when you go to sell that house, you have to tell the buyer, this house is non-conforming. However, if you go to the Windemere, you could possibly get a variance to the new law.
What would the variance be for?
Because you want to add a garage or a kitchen or anything else, a deck, anything that requires a permit, that house is non-conforming, is that right?
It's a non-conforming use at that time.
It requires a variance.
So,
90% of all
I'm
the
sorry.
lots, 90% of the lots in the shoreline district are non-conforming.
Well,
Correct or not?
here's the deal. These hypotheticals are very difficult to try to understand when you provide not much information.
It's a typical lot. This is say,
Well, okay, so define a typical lot.
it's 100 feet wide and 250 feet.
Okay, what district are we in? Are we in ag? Are we in R2, high density?
R2, typical is R2, the shoreline overlay.
Okay. So you are already non-conforming based on the previous ordinance, number one. The 2015 was non-conforming already. That's a 2.5 acre. So it's been non-conforming already.
No. In 2016, if I wanted to build a garage, did I have to get a variance?
Sir, so the answer is, it depends where you want to put the garage. Because if you can meet the setbacks for the new development, it doesn't matter if your side yard is non-conforming. So if you want to, if you have a side yard setback that's non-conforming, but you're building the kitchen on the other side and it meets the setbacks, then you get a building.
But you go through a variance process?
No.
You do not go through a
No,
variance
not if the addition meets the standards that are in place.
Okay, so all these non-conforming lots, they're now non-conforming lots. All those lots, if you can build using the setbacks, then you do not require a variance.
If they build in the setbacks, you have your septic, and you don't go over your hard surface, then you don't need a variance.
Okay. So do you know what percentage of houses currently in the Lakeshore overlay are themselves not compliant?
No.
i.e. setbacks?
No.
If you wanted to go ahead and study that, we're happy to, get back to us on that. No problem. No problem at all.
This is something I would think you would consider though, because you talk about the cost of sewer costs, et cetera. The amount of lost value to everyone here far exceeds installing a sewer line.
I'm not so sure I would agree with your statement about lost value. Here's why. In 2020, the valuation of Windemere Township was about $200 million, okay? There's 33 townships in Pine County. $200 million in 2020. Can anybody guess what our valuation is now in 2026? I'll just tell you. Right around $600 million. We're not losing value, sir. We are gaining value, and that's not going to change.
That's not true.
Well, it certainly is true. I've been in real estate for 23 years and have sold my fair amount of properties in this area, and so is this lady over here, and so is that lady over there.
So you're saying that you study the issue and that the people here will not be losing value?
Absolutely not. No, if you've got something to sell, give me a call. If you have to take a look at it. So all of us. We're going to move on. Anybody else got a question? Otherwise, we're going to move on with this. I'm going to take whose ever hand is up right now, and then we're moving on. You, sir.
It's Derek Berg with Cousins Construction. You mentioned some percentages earlier about sewers and how they were...
Talk a little louder, come to the microphone.
Yeah. So you mentioned some percentages earlier about sewers, referencing that. Could you share a little bit? There's some folks that asked about that. Maybe you could share the source so they can look it up.
So according to the MPCA, 25% of the shoreland septic systems are failing That's Minnesota Pollution Control. Out of that, 25%, 39% are an imminent health threat, meaning requiring immediate attention. So when that leaks, Tom Anderson's an expert in this, I mean, that can get into your groundwater and cause contamination. It also gets into the lakes as well. Thus the reason for bigger lots until the sewer comes in for new development.
Is there a year on that?
Pardon me?
When it was done?
I can't answer that. I don't have it in front of me right now. It's in my brain. I'm not sure that's
Because
very good.
septics have changed a lot over the years.
Well, they sure have. Yep, that's correct. And they also are failing. In Windemere Township here, if you don't pull a zoning permit, you're not getting inspected, period. So if you've got a 60-year-old septic system and never pulled a permit, I will guarantee you it's leaking. And also, I will guarantee you the 102 lots on Sturgeon Island, there were straight pipes going into the lake. Covers coming off of holding tanks being pumped out onto the ground. There's record of all this stuff. If you folks want that to continue on, so be it. Not on my watch.
I had to move my well because that was happening on the Blight property next to me. So it's very expensive with the septic and issues with them. And there's a lot of them failing in our township.
All right, we got 3 more questions here. Go ahead.
I know that I should have probably spoke, but I figured no one would listen. I want to address this camper issue because that's ridiculous.
Okay? Why don't you come to the mic and tell us about the campers?
Let's, if you can turn it on, I think I turned it off, please. It's up at the very top, kind of. Thank you.
The way I understand it is you can have one trailer, fish house, whatever RV. Recreational vehicle on your lot, no matter what size it is, you can have one in the new ordinance. And if you're going to use it, it has to be hooked up to sewer and also have a permit. What I want to say is that we bought our place in '95. Why did we move from the cities here? Because we wanted to enjoy it, have family come up. There is no, unless you have a tent, you can't do that, the way I understand it. Also, why can campgrounds have caddies if they want to empty it, if you're going to use it? I mean, we use ours for camping, but basically it said that you can never use it besides that. And I think we got to think about this. People have family up. There's got to, I'm fine with having some restrictions, but this is ridiculous. One. So that's what I want to discuss.
I'll address that. So we've had an RV ordinance in place since 2015. And Phil White can attest that it's not been enforced. And so the enforcement tool is now in place. The statute or the ordinance is more clear. And with that, you do have to meet your septic standards. Because I'll tell you this much, and maybe, I won't name names, but it's somebody in this room, I'll leave it at that, has witnessed people opening up their gray water on their camper and dumping it into the creek and going into Sturgeon Lake. That's a real scenario. I don't know if anybody would want that situation next to you, or going into the lake and having your kids or dogs or people you love swimming. It's a real problem. We have camper issues in Windemere Township. To the best of our estimate, we have over 400 campers that are unregulated with sewers, and that's a problem. And with your situation, it's very clear in the ordinance. You can use them if you have an approved drop tank with a pumper agreement to take care of the waste. Okay, otherwise you'd be connected to a system, a holding tank at the very least. So we feel, and I think it's been the mantra here, is we have issues with septics, not only with structures, but with RVs. And so we're trying to get a hold of that. And we feel now with WSB as a planner and zoning with over 30 years of experience, to apply this across the board to everybody and start working on this stuff here now. And we all realize it's not going to be perfect, but we got to start somewhere, and we can make adjustments as we go along. Now, I said 3 more. Now, who were they? It was Tom and that fellow right back there. Go ahead. Tom?
Okay, first is, I personally would suggest a levy. I would pay for an employee to do inspections around this lake, because every word you said is correct. Okay? I have seen people take their holding tanks, put a pump in it, take the hose and pump it out on the ground. And it's more than anybody would believe, okay? So that's number one. Number two, I would ask, as one of the landowners that has land that has more than 300 foot of lake shore, you reconsidered a lot of stuff, thank you. I would ask you to reconsider the 300 foot back to the 150 on the recreation lakes and stop a lot of hassle for a lot of people. It will improve the tax base and leave the 5 acres if you have to. I'm just saying, please consider that. It's a respectful request, okay?
Thank you, Tom. Corey?
2 quick things. So if we look at page 64 for the impervious surface, we just said that it's 25% across the board. It's not the RR district, it's 20% for sewer and 10% for unsewered. I would suggest that it's 25% for all of the districts. Second point I want to make, as we discussed earlier, if you're in the shoreland overlay district, right, your setbacks are different than if you're just in regular R2 district. But this ordinance says you have to follow whichever one is more restrictive, and you have to follow both. So the scenario that came up earlier of how many feet have to be off the center of the road wouldn't be the 20 feet that you just talked about putting into the ordinance. It would still be 73 feet in the R2 district. So that didn't really solve the problem.
Well, no matter where you're at, if you're on a county road, you're 73 feet off. And that's the county
Just making
regulation.
the point that
Yep. Thank
it's,
you.
you have to follow both, and it doesn't make a whole lot of sense to change it. It's just 73.
You've been persistent, so I'm going to let her go here.
Camper issue. I've got 2 lots, 100 foot, 100 foot. I've got a cabin, pump house, tool shed, telephone pole, or electric pole, guide wires that come down it. I can have, according to the new standards, 1 camper. I've got a 100-foot lot next to it, empty, nothing on it, but campers. To say I can have 1 here and only 1 here, I think is unrealistic. You know, in the cities, if you want to build a deck or garage or whatever else, it's always a percentage of your property. It should be the same way with campers. I can build a cabin there, but I can't have 2 campers. If it's an undeveloped lot, I think you should be able to have more, if it's undeveloped.
Are your campers connected to septic system?
We're trying to get there. We turned in our paperwork 3 years ago to you guys along with our $100 checks. We're still trying to get, we haven't got any answers from you guys. We tried to get somebody to come out and do the survey to put in the additional holding tank. Trying to get somebody around here to do that is extremely difficult. Everybody's extremely busy. And I talked to Jason during the break and stuff. You know, my other question goes to him too. We're hearing a lot of grumbling from, you know, like Mike's sewer system and the rest of these people. They're already at capacity. They're having a hard time dumping. I want to do the sewer system just like everybody else, meet the standards. But have you guys looked into how those companies are going to be able to dump that if everybody starts putting in additional sewer systems?
Well,
where are they going to dump it?
So 2 things to clarify. Pine County manages our septic systems, not within your township. So you would have to apply through them and go through their process. We complement each other in the process, and so that's number 1. This goes back to the point we've been making. We have a sewer problem. We have a septic problem, not only in Windemere Township, but Sturgeon Lake. To say that, well, we shouldn't hook up to it because there's no place to go with it, that's a pretty silly statement.
We're not saying it. I didn't say that.
Well, that's
I
what I
said we're
heard.
willing to follow that. We're trying to get there.
Yeah.
But, you know, like I said, the base point I'm trying to make is it doesn't seem realistic if you can have 1 camper with the cabin and all that other stuff, and you've got an empty lot, but you can only have 1.
Sure. Well, the goal is to get people to build, I think that part of the goal is to have people invest in their properties. You want to talk about values and increasing your value, put a $100,000 cabin on a vacant lot, or put a $10,000 camper. What's worth more? Think about that a minute, okay? All right, any more questions? Otherwise, we're moving on. Yes, they are.
So I can only have one problem on my property?
Depending on what district you're in. There's 2 outside of shoreland, 1 inside of shoreland.
So I can't store my family, I got 80 acres, I can't store my family's pop-ups at my property away from view of anyone else?
Right now, it's 2 on the property outside of shoreland. That's what it's written as, okay?
I was at a meeting where the people like Sewer Service and other sewer companies were asking for agricultural land. I did not say I would put my land on there for it, but my concern is if we're allowing people to come and bring their pumps and put it on agricultural land to get rid of some of that sewage. I don't agree with people dumping it on campers either. I don't want manure from feces from people or anything else going on to the land where you never been water. But can we think about letting people do that on agricultural land? Our agricultural land does not allow that. However, there's agricultural land in Windemere Township that is allowing sewage going onto that. It's only going to create more if it goes to an aqua.
Well, so that's a whole different conversation beyond today, and it's a good one. It's very important, but
Because it's kind of counter.
the town board sets that precedent, and I believe at this point, the lot that they had designated over by the golf course in Lord's Lake is no longer being used, so that's not happening anymore.
Also on that, with that question that you had about that stated allowing sewers to be pumped on agricultural land.
Can't hear you.
There's restrictions on how they do it. It has to be treated before it's pumped on the agricultural property. And the sewer for, I'm just trying to continue with this thought, but there's the people that have home sewer systems, that's way more contaminated with chemicals than agriculture. If you go to your house, look underneath your kitchen sink, and look at the chemicals that can be dumped from your residential sewer on your property if you're doing that. So there are restrictions, there's strict regulations on what they can and can't do. It's not just a matter of human waste, it's more complicated.
Okay, I promise you, last question.
As far as the RVs and campers and stuff go, like on my lot, for instance, we have a cabin there.
Can you clarify, where's your lot?
It's off the Lake Town Road in Sturgeon Lake, just off the highway.
Lake Town Road. Okay.
Yeah, we're 3 lots from, what's the bar called? What used to be the Red Oak.
Okay.
Parker's. Yeah, Parker's Sandbox.
Sure.
And we have a little cabin there, and our family all comes up and gets together. The cabin's not big enough for all to sleep in. We have a toilet, we have a well in the cabin. We use our campers for sleeping in, and that's about it. Is there a reason that we need to have those hooked up to septic or sewer or anything like that if we're not using the bathrooms?
I think Kim would be able to clarify that. There's some language in the ordinance that would allow something like that. So.
And we also have a big family, so there's
Correct.
3 campers as it stands, along with the cabin. And we've done that for years and never had any issues with it.
Yeah. Thank you. Okay, I got to address something here from Dave. So you talked about public water wetland that you built on there.
Curious what you talked about the setbacks you guys are referring back to on the residential. What about is that a natural or natural environment?
It's a natural environment lake.
So those are still 150 then?
Correct.
You know, I would ask that you guys change that back to 75 or, because that land went from having no setback to now having one of the strongest setbacks in the town.
Well, we have many natural environment lakes in the township. So there was let's just say a misunderstanding with the DNR in the process 2 years ago of a development in the area, and that got clarified. Even the DNR was a little bit taken back, but when you look at the fine print, it was called a public water wetland. Okay, that's what it was classified as. And so the town board, to help clarify moving forward for any future development, they felt that they wanted to put that into a natural environment lake as a reclassification. So we worked with the DNR, sent the paperwork in, and some things didn't make sense, what they were sending us back, so we questioned them more as to what, as far as how this process goes. And the head gentleman at the state said, no, you don't reclassify that, it's not even classified, it's a wetland. All right, what's the process? If you guys want this, from a township perspective, want this as an NE lake, just let us know and we'll do it. An hour later, they sent us a letter back and said it's a natural environment lake, it's done.
It was done.
So now what we have to do is we have to adopt it into our shoreline ordinance, which is what we're doing now.
But then will that have a 75-foot setback or 150?
The DNR requires 150 on an any lake.
So Dave, what is it that you need beyond the house that you have? Is it a shed?
Yeah, it's just a little shed there.
So can we address the shed from a natural environmental accessory shed? Is there any way we can address something like that? Because I know where his concrete pad is.
So we have the 100 square foot shed.
I'm not quite sure what size it is.
It's 16 by 10, so it'll be 160.
160. So,
I would prefer not to address that now. I think that if Dave, with all due respect, you fill out the application, go to zoning, they look at the criteria and go through the checklist, and then we will, once this is done, correct?
Yeah. You know, as we discussed, if people have very specific questions about their property, it would be easier to talk to you one-on-one. Either call or send an email, and we can follow up individually rather than trying to guess the answer today.
But does the township have the ability to change the setback from a natural environment?
No.
So this goes into stone, April or something, you said?
Say that again, please.
This is finalized when?
So the town board, once we get done, we make a recommendation to the town board, and that has not been set yet, because it hasn't gotten past this group of people. Yeah, there's plenty of time here, so. One thing I want to address here is the impervious surface. As to why in RR it's 20 and 10.
Because the lots are bigger. So, I think
Bigger
we have
lots?
to make the
I see,
adjustments
okay,
based on the changes.
gotcha.
If we're changing the lot sizes for the R
Yeah,
to
okay. So what I'd like to do, anything else?
Can I go back to something that Noah mentioned?
Sure.
He mentioned about the licensed engineer on the steps and different things. That's also added under the section for roads, driveways, and parking areas. And I certainly understand it for roads, but I don't understand why you need a licensed engineer for a parking area. So that would be one
What page are you on?
7. That I would like to see changed, and that ties into perhaps yours with, do you need licensed engineering for stairs?
Well, I'll address, in my opinion, the easy one is the stairs, and I'm a strong proponent of that in the bluff area, because we've seen too many instances where the bluff has been destroyed, which causes erosion, and that potentially could go into your neighbor's property. So we've had too many homeowners decide to take it upon themselves, and there was some people in here that have had issues with their bluffs, neighbors causing issues. And I know one of them has spent close to $300,000 to try to fix his issue. So personally, I have no way of compromising on that issue. If you're gonna be going into a bluff, over the lake, you gotta have somebody that has a background in this. We also have a property on Sturgeon Lake that is falling into the lake right now because there was no engineered plan. So no, I have no way to even consider a change on that, but you guys can have your conversation.
There was also another one, I'm not sure that's the one
You were talking about with the $300,000 that he spent trying to control it. I think they live over by you. And if they would add an engineer, do the short line down to the lake, they would have saved $300,000. I'm not for, I mean, if it's just a stair, when you explain it that way, it's no big deal, but it's not. It's a big deal. And they have to have a certain amount, they're so far off of the bluff, you can't lay them on the ground, and just to make, I don't think you have to have an engineer. The way I read this, you don't have to have an engineer come out and design you a stairwell to the lake. It has to be approved. They can come out and say, this is what we're gonna do.
It's actually, you do have to have an engineered plan for stairways going down to the lake in a bluff.
In the bluff. Yes, but I think, well, I'm gonna leave it at that.
Well, I can understand if somebody's doing like a retaining wall or something massive, certainly, but maybe we have a limit, maybe there's a limitation where, you know, if it's certain size, stairs going down or something, where you don't need an engineer.
That's in the ordinance, 4 feet wide, and landings are limited to 4 by 8 feet. And the pieces of property that Vern was referring to, I was there actually when one of them let go and watched the whole thing happen. But that's different. That's people who are clearing vegetation from their slope. And also, one of the other properties on Sturgeon Lake, the home was constructed in the bluff zone, into the bluff. And then there was a cut made by, I guess, some kind of device, a cut down the lake. It wasn't just stairways and landings. Stairways and landings are placed on the bluff. What you do is you put footings on the bluff, and that footings, depending on what you're talking about, can be done merely through inspection by the township. So I guess I don't understand. You're going to have a lot of people building stairways without informing the township or getting a permit, because it's anywhere from $2,000 to $3,000 to get a licensed engineer to come out and make a comment on it. So it's unnecessary cost and it creates enforcement problems.
Well, we've always had a rule that they have to be inspected going in, and they've already ignored it. So I think what we're trying to do is tighten up that rule a little bit.
But that's enforcement, that's not the licensed engineer.
Yeah, but we don't even get to
So
enforcement.
we're gonna get there, you know, enforcement does, in any municipality, it's enforcement. Well, and you would know that, there's a process that it goes through. And I think now moving forward with consistent zoning, an unbiased company that can do this, they've been consistent from the beginning, and that'll continue moving forward, so go ahead.
So then to the parking areas.
Yeah.
You know, maybe it was meant commercial parking areas. It doesn't say that, but it's on page 70, 10.13.2.
Yeah, I think we should study this again a little more and see what DNR requires. I'm not sure what they have in there, if it's just strictly the shoreline park or not. But I think that's reasonable to take a look at that and to see what their language is. So, thank you. Anything else? Okay.
I would like to address Tom's question regarding lot width. 300 feet, 150 feet. I think that has been a big question for a lot of people. I've heard it numerous times, that 300 feet is excessive. I think we should consider the 150-foot lot width. I understand the 5 acres, but I would like to have that discussion. It'll be a long, skinny one. But I think the option of having the lesser at 150 feet is something to consider.
I would agree.
I would say the important thing is the proper septic system. Okay? That's a lot of enforcement is around that. A proper septic system with a mound that does not infiltrate the aquifer and lets Mother Nature do its job on the top of a mound is harmless to the ground. Okay? And that is what's being demanded in Windemere Township. I just put one in for $30,000 on a lot of it. Okay? There's no harm. The septic system is more important than the width. It's just that simple. And you guys just get enforcing that. You got a good system to do it. Enforce it with those guys, and we'll clean that lake up.
I would like to make a motion that we change from 300 feet lot width in the shoreline to 150 feet.
And I'll second.
Any discussion?
The 150 foot, 5 acre lot is, you could put a lot of 150 foot lots in the shoreline, and I think that helps to control shoreline. And if I was going to make a recommendation, I would probably go 200 feet.
We can't
So the motion on the floor, and I'm going to say this, I'm going to hold on this, we may respectfully disagree over at this time. Until we get the sewer in, we got to continue to have some distance here on these lots with density. And you folks have a very unique piece of property, and so does the Nyströms, and so does Al Overland, who is the board chair. This directly affects him. And so yeah, I don't, I'm not going to change my position on this at this time, but we're going to call the question. We're going to start with 3. All in favor?
Aye.
Amy?
Aye.
I'm no.
No.
And Dick is no. Motion fails. Okay, here. So here's what I'd like to do. Did you have anything else on that?
I do. I'd like to talk about the agricultural district. We're currently recommending 20 acres. I would like to see it considered to be 10 acres instead of 20.
Would you like to make that motion?
I'll make that a motion that we look at 10 acres within the agricultural district, opposed to the 20 acres currently recommended.
Is there a second? Discussion. I guess I could start on that. Windemere Township, based on that map on the east half of the township is ag property, and then the south half, down the south corner down there, that's the special protection district along the Little River. A lot of lowland, although the Lisinski farm is sandy property there, but this is a rural community, not a subdivision, not a metro subdivision, and a lot of people come here for that, and a lot of people live here for that. And so if you want to have an agricultural district, and have some chickens and a couple cows and a horse, you know, 10 acres, it may not be enough, depending on what you want to do. And of course, have more density, if you want to maintain your rural characteristics of the township. And so I'm not going to be in favor of changing that down to 10. So you guys can have a conversation, anybody else?
I'd like to maybe study it a little bit more.
Sure.
10 acres, I have a community that does that, and it's like that. Well, I don't think they have any horses.
Yeah.
It's just strictly residential.
Sure. Yeah, so that's in the residential district, not the agricultural district, is what you're saying. And you're referring to May Township, correct?
If we were going to do this, I think it should be discussed in the future to change these. It can be adjusted at any time. But I think in the ag area, I don't think 20 or it's what we have in now is really
Can you
that.
speak into the mic? I'm having trouble.
I don't believe that I would agree with the motion.
We'll call the question. All in favor?
Aye.
Amy? No?
No.
Dick? No. Motion fails. Okay, so what I'm going to propose here is a motion to table the recommendation until the 16th and call a special meeting on the 16th of March to allow us more time to study, have our planner put everything in the amended form on addendum to reference what's changed. We'll get that out to the public on the website. A special meeting requires 5 days' notice, posted on our board. We will do that. So my motion is to table this and call a special meeting on March 16 at 9:30 a.m. at this location.
We're not extending this.
No. We'll just table it. We're going to have a special meeting with this as an agenda item.
For the ordinance. and
For the
changes.
ordinance and the maps, and then we're going to get to the short-term rental here next. So does anybody have a conflict on the 16th at 9:30? Nobody?
Let me look.
No problem. Take your time.
So the items on the agenda would be, what again exactly?
Well, at this point, for a special meeting, we have to post that, but I'm going to carry this over as an agenda item for specifically the zoning map, the zone, or the shoreland overlay map, and the draft zoning ordinance, those 3 items.
We're limiting conversation to what we discussed, right?
Well, that would be the agenda item for the 16th one at this point. Anybody have a conflict with that date? On the 16th? No? Okay. So that's my motion to table this until our special meeting on the 16th.
I'll second it.
Any discussion? All in favor? Aye. Motion carries. So now to switch gears a little bit here and get the short-term rental out. And let's go through those amendments, please. Should be in your packet here somewhere, the short-term rental ordinance. There's a few amendments here. It's this right here. Short-term rental. Oh my gosh. All right. Kim, are you ready? Or Grace, do you want to take this? You want to take this one? Or do you want to default to Kim? Default to Kim.
All right.
Okay.
So, Chair and members of the commission, we, started implementing the short-term rental. We've been doing the permitting process. There's been a couple of things that have come up, and so we're trying to make some modifications to reflect those comments or issues. One in particular is the addition of those basins that were added to the DNR, that were added by the DNR. We talked about that at the last meeting, that we were going to allocate some units, some short-term rental units to basin 580072000. That's reflected in the ordinance, and we are not adding allocation to the other three natural environment lakes. The other thing that has come up is regarding definition of bedroom. We've had some conversation with folks who have wanted to put a bed in a living room, or a bed in an attic, or a bed in a basement, and call those bedrooms. And so the language you have in front of you is to kind of rework the bedroom definition so that we can address those more clearly. The intention is to not just put a bed in every room possible and call it a bedroom and increase the occupancy. And so that language that's in the ordinance is what was recommended to us from the attorney. And then the final change is based on the conversations we've been having about in the shoreland, about the accessory structures, or the ADUs, or the cottage, we call them kind of a couple different things. And so we allow that accessory structure that has that habitable space in the shoreland. However, the ordinance was a little ambiguous about whether that use, that structure can also be rented as part of the short-term rental. And so the language we're proposing, based on prior conversation, is that that cannot be considered. So you can have the house as your short-term rental, but any accessory structure is not included as part of the short-term rental on the property. The intention is to have one structure kind of be the accessory for the short-term rental. And then I think the other ones were just kind of clarification. We talked about at the last meeting was just the numbers for the individual lots or the individual lakes, and then just reaffirming that the advertisement has to be consistent with your permitted occupancy. There was language in these before, but we just kind of turned it down for clarification. I think we had a conversation about most of these previously, but we're available if you have any particular question.
So Kim, you have something called a draft here, an ordinance amending the short-term rental ordinance 2025-007, correct?
Yep.
This amendment, what you just spoke about is all on the amendment, correct?
Correct.
All right, commissioners, you got any comments, thoughts, questions on this? No, we got a couple of comments here that I want to address. Going back to the beginning. So we got to remember that this ordinance was approved by the town back in 2024. It was never administered since then. We couldn't get off the ground on it. It just didn't work. So until WSB came into play, they've been instrumental on this process, getting the application prepared, going back to Kim and Jessica prior, and now Grace has taken over, and they're doing a great job at this, and people are applying and trying to meet the standards for these short-term rentals. The question that was asked is how many STRs are on a lake. Jace, this has been a 6-year conversation. I don't recall how that got determined 6 years ago. And of course, the criteria, I think, is clear in the ordinance as far as what will make an STR. So hopefully that will answer those questions. And if there's no other comments from the commission, from planning, I'd like to make a recommendation to forward this to the town board for their approval at their next meeting.
Is that a motion?
That is a motion. Is there a second? We have a second. Any more discussion on this matter? Hearing none, I'll call the question. All in favor?
Aye.
Aye. Motion carries. With that being said, I'll entertain a motion to adjourn this meeting.
I'll make a motion.
Phil and then Dick, all in favor? Aye. Meeting is adjourned.